I've got huge news for you. It's another win, and it's such a big one that it's probably going to cause a rewrite of this thing right here, which is the 4473, which is the form that you fill out every time you buy a new firearm. But I'm not entirely sure this is going to make it through the rest of the Second Amendment news community. So if you feel so inclined, if you find this video interesting and informative, please hit those buttons down below. Interact with the video in some way, because we're not getting any help from YouTube these days. And your few seconds it takes to push those buttons signals to the machine that more people need to see this video. So I thank you very much. Now, the reason I don't think it's going to perhaps make the cut is because it seems like kind of a sleeper issue. But I assure you that the amount of copium that is being poured on this from the mainstream news outlets, like, I'm going to take you to a few articles here in a second, and you almost can't make it through the articles because of the amount of cope that is being slathered on top of it, because this is a big thing. So the court case that we're talking about is out of the Third Circuit based in Philadelphia, and this is an 11-4 ruling, our direction. So win, in which the court essentially rules that they cannot take your weapons from you for non-violent and particularly misdemeanor crimes. So the situation is this. We have an individual, his name is Bruen, and the case is Range versus the Attorney General. And basically, I won't get into the nitty-gritty of it, but he committed a misdemeanor crime, okay? Non-violent misdemeanor, some fraud, and they took his guns away. And he's like, the Bruen decision says you can't do that. So he sued. And initially he lost, but then he appealed it to the Third Circuit, and they're like, hold on a second. You can't do that. And where the background of this comes in is, if we go to the 4473 for a second, are you under indictment or information in any court for a felony or other crime in which the judge could imprison you for more than 1 year? Have you ever been convicted in any court, including a military court, of a felony or any other crime for which the judge could have imprisoned you for more than 1 year, even if you received a shorter sentence, including probation? The conclusion that the court came to was that the government failed to show any text, history, or tradition that shows that non-violent crimes should be punishable by revocation of your constitutional rights. Now on to the copium. From ABC, federal criminal law generally bars people convicted of crimes punishable by more than a year in prison from possessing guns. Such crimes are usually felonies, but the law also includes some state misdemeanors, like ranges. When asked, the ATF declines to comment. On to the New York Times. In the majority opinion, Judge Thomas M. Hardiman repeatedly cited the Supreme Court ruling last June, written by Justice Thomas, in which the majority established a new standard that dictated that gun laws conform to the historical tradition dating back to the 18th and 19th centuries. The New York Times also questions the Justice Department, and they declined to answer, but they did get a little bit of a nugget from the attorney for the plaintiff. He believed it would make its way to the Supreme Court if the Justice Department was unwise enough to appeal. Now on to the actual decision. I really just want to show you one snippet and give you an overview, because I didn't read the entire decision because it's 107 pages, and more than half of that is the dissent, basically crybaby whining for pages on pages about the broad-reaching unintended consequences of the majority decision. Yes! And ain't nobody got time for that. So, basically what the judge said is that the defendants tried to, on multiple occasions, point to contemporary state laws that were, in essence, an attempt to weave back into federal law. So basically, states trying to pass laws to change the federal court system on how they view various crimes. And the judge said this: a conception of the Second Amendment right that retcons modern commerce power into early American state law is anachronistic and flunks Bruen's history and tradition test. Setting the federal floor through a combination of antebellum state police power and Congress's post-New Deal Commerce Authority, as the dissents propose, would underprotect the constitutional right to keep and bear arms. So basically the judge said, get out of here with that crap. They didn't do this before, mostly because if you committed a capital crime, they just hung you. But there's no text, no history, and no tradition of disarmament of nonviolent criminals. So, boop. Eyes on it to see if it goes to the Supreme Court. Part of me is like, well, I hope they just kind of leave it there to sit. And part of me kind of wants it to go up to the Supreme Court so that they can just Let me know what you think in the comment section down below, and thank you for watching the VSO Gun Channel. Hopefully we'll see you on another video here soon, provided that we don't get censored.